$3,000. Good morning. I am Judge Martin. This is courtroom number 1. Today's docket is exclusively landlord tenant cases. If you do not have a landlord tenant case, you are likely to be in the wrong courtroom. You can send a chat or message to Mary Ann, that is my secretary. She will help you get where you are supposed to be. These cases were originally scheduled with Judge Oakley. They were adjourned to this morning's docket, which means these are at least the second hearings in these matters. All parties present this morning should have already seen the advice of rights video, should have already had the opportunity to review a printed form of the advice of rights. If when you appeared with Judge Oakley, you requested an adjournment to file for rental assistance, today's proceedings will include an update of your application. Other than that, I see that attorneys are just starting to arrive. I will call the cases in the order they appear on the docket. If you would like to speak to the attorney, we will get you moved into a breakout room with them. Please be prepared to have your videos on when your name is called. When the case is called, tenants, defendants, you will need to state your name for the record. Sir, remove your cap. This is court. Anyone who is driving, stop driving. If you're smoking, stop smoking. If you're eating, stop eating. That being the case, those being the ground rules for the morning, we will start with Mr. Draper at 2303555 LT, Maxwell versus Draper. Your names for the record, please.
Michael Draper.
Mr. Draper, how are you this morning, sir?
I'm doing all right.
I wanted to let you know that I see you. Mr. Katz, the attorney for the Maxwell, is not present. Have you made an application for rental assistance, sir?
Yes, I have. I filed it on Monday the 5th for DHS.
I'm sorry, you filed it. You filed with DHS on what date, sir?
The 5th, Monday.
Monday. Did you submit the form to the court to advise the court that you filed that paperwork?
I was notified of that when I checked in this morning, so I got the number for that paperwork, and I'll get it off the website and get it filed today.
Okay. So, Mr. Draper, when you appeared on January 17th, there was no conversation about the application for assistance?
No, I didn't apply before that because I didn't know if I was able to until I had my first court date. So after that, I filed it before this one, and then no one told me that I needed to fill out that paperwork for you guys to be notified, but I can get that in today.
Okay, then Mr. Draper, what I will have you do, I will release you before, oh, here's Mr. Joseph for the Maxwell. Hold on one moment. Mr. Joseph.
Hey, good morning, Judge. How are you?
I am super. How are you this morning, sir?
I'm doing well, thanks.
I just called your first case. It is 2303555 LT. Michael Draper is here. He's advised the court that he's made an application with DHS for rental assistance and that he'll be filing the 539 today. The court's inclination is to adjourn this matter for a final hearing on the 22nd at 1 p.m.
That's the 22nd, I'm sorry.
February 22nd at
Okay.
1 p.m. Mr. Draper, please get that DC 539 filed, and when you appear on the 22nd, be prepared to provide an update regarding the status of your application, okay?
Absolutely. Thank you so much.
Anything
Okay.
else, Mr. Joseph?
Yeah, I just wanted to clarify. I mean, it's fine whatever the court decides, but my understanding is the rental assistance app was not filed at the first hearing. These are up for second hearings, correct?
Correct, sir.
Okay. I just wanted to double check that. Okay, no problem, Judge.
We had that conversation before you joined.
Oh, okay.
I understand. We're on the same page, Mr. Joseph.
Okay.
Thank you. Mr. Draper, I'll see you on the 22nd at 1 p.m. Court staff will mail you notice. You have a good day, sir.
All right. Thank you. You as well.
Thank you. 2303. Sorry, Mary Ann, I'm trying to. 559 LT, the Maxwell versus Veronica Williams. Your names for the record, please.
Joe Joseph for plaintiff.
Miss Williams.
I'm so sorry. I didn't know how to. Good morning. My name is Veronica Williams.
Thank you, Miss Williams. Today is the day and time scheduled for the second hearing in this matter. Miss Williams, have you made an application for rental assistance?
No, ma'am, I have not.
How did you intend to proceed this morning, ma'am?
Well, for my refusal to pay rent was for issues within the apartment.
Did you raise those issues during the first hearing?
Yes, ma'am, I did. And then they told me I will have to come to a second hearing.
Who told you that, ma'am?
The attorney, when I was put into a breakout room, he told me that I would have to take whatever issues I had and come to the second hearing.
Ma'am, we'll finish going through this docket call and I'll put you in a room with Mr. Joseph. He only has one more case I need to call from the 9 o'clock docket. Go in there and
Yes, ma'am.
discuss it with him. When you come back out, I'll recall the case, okay?
Yes, ma'am. Thank you.
Thanks, Judge.
Mr. Joseph,
Yeah.
you were starting to say something?
Oh no, I said that's fine, Judge.
Okay. Ms. Williams, he'll be there momentarily. Thank you. This is 2303563 LT, the Maxwell versus Zaria Riley.
Hello, good morning.
Joe Joseph for plaintiff.
My name is Arya
Could you
Riley.
state your name for me? Thank you. Have you made an application for rental assistance?
No, I have not.
How did you intend to proceed this morning?
I was hoping to get my balance and have it paid by the 16th of February.
Mr. Joseph, the rent to retain possession in this matter?
$2,865.
Got it. Thank you so much.
Oh, well, hold on, ma'am.
Is that a correct amount?
There are court costs, Judge, of 168. So the total arrearage is 3,033.
Okay. Thank you.
Do you admit and agree that that's the correct amount of rent claim due and owing the $2,865?
Yes.
And your indication is that you need 2 weeks to pay that?
Yes.
The typical period is 10 days, but in as much as you admit and agree that that amount of rent claim due and owing is accurate, there's no triable issue of fact, and plaintiff is entitled to entry of judgment in that amount, plus the applicable court costs. The court will enter a judgment that indicates $3,033 in total with 14 days to pay. I know that's beyond the usual 10 days, Mr. Joseph, but humor me, with a pay or writ date of February 21st.
That's
Judgment
fine. I
after
believe she said,
hearing.
yeah, Judge, I believe she said that she'd pay it by the 16th. I'm fine with the 21st. It's not that big of a deal. But
Oh, I'm sorry. I thought you said 2 weeks. You said the 16th? I'm sorry.
Yes.
16th. Thank you, Mr. Joseph. 2/16.
We'll keep it though, because the 10 days is the 19th with the weekend. So I don't know if the court's closed on the 19th, so either the 19th or the 20th.
The 20th.
Okay.
See, the 21st was fine.
I know. That's why I said I'm not going to make a big deal, but I just wanted to, I
2:20.
wanted to verify if she needed that extra time. But okay, no problem.
Anything
Okay.
else this morning?
No,
Nothing.
that'll be all.
Thank you. You have a good day. You're free to go. You'll get a copy of the judgment in the mail in a few days. Mr. Joseph, we received the dismissal of 2303557 Maxwell versus Young.
That should be correct. Yes.
If you would go in and speak to Ms. Williams, I'll recall the case when you come back out.
Okay, very good. Thank you.
Thank you. Marianne, what do I tell you all the time? Is that first one or two cases that are super rough. Everything else kind of smooths out.
It will.
This is 2303566 LT Holiday Woods versus Keyshawn Webb and Kayla Yarborough. May I state your names for the record, please?
Kayla Yarborough.
I'll
Keyshawn Webb, I'm sorry.
Today is the day and time scheduled for the second hearing in this matter. Webb and Yarborough, have you made an application for rental assistance?
Yes, but we will not be going through them.
How did you intend to proceed this morning?
I was trying to see if I could get in the breakout room with the attorney so that I could make a payment today and then my payment for February on the 14th.
You'll be able to pay it all by the 14th?
No, I'll make the whole payment that they're asking for today.
Oh, Ms. Kuzi, what's the balance to retain possession in this case?
Yes, Your Honor, as of today, the rent to retain is $2,604, cost of $246.29 for a total balance of $2,850.29.
Is that included with February?
Yes, that includes February rental charges.
No, what I was saying was I can make the full January payment today, but I would need one more week up until the 14th to make that February payment.
Ms. Yarborough, Ms. Kuzi has two more cases I need to call.
Okay.
Or one more case, actually. We'll move you into a breakout room. She'll be there momentarily. And she'll talk to you about a payment plan. If you have an agreement, well, after you talk to her, you'll come back out in this main session and we'll figure out what we're doing, okay?
Okay.
Thank you. This is 2303606 LT Holiday Woods versus Sean Wakus.
Introduce
Yep, Sean Wakus.
Thank you. Sir, have you made an application for rental assistance?
Yes, I have. I got paperwork right here. It's a phone call. Meeting is tomorrow at 11 a.m. at over the phone for DHS.
You made an application with who, sir?
DHS. Actually, my fiance that lives with me in the same place, she filled it out and she has the meeting tomorrow at 11 a.m. over the phone.
When did you file? When did she file the application? Does it indicate on the top of the page?
125 of 24.
Sir, there is a form that needs to be filed with the court called the DC 539. Were you advised that you needed to submit that form to the court?
I think I was, but I forgot about it.
Then, sir, what will happen now is that you will go into a breakout room. Court staff will discuss with you how to file that form. You have 5 days to file that form. You will come back to court on February the 22nd, 2024. You will need to have filed that form, that DC 539, and on the 22nd, be prepared to provide an update from DHS regarding the status of your application, okay?
Okay.
Anything you'd like to say regarding this case, Ms. Kuzi?
No, Your Honor.
Thank you. Mr. Wakus, we'll move you in with court staff now. They'll talk to you about how to get connected to that 539 form and get it submitted to the court, okay?
Okay.
Thank you. And then Ms. Kuzi, we received the dismissal in 230608 LT Holiday Woods versus Kamitra Torres.
That's great. Thank you, Your Honor.
Thank you. So if you want to head in with Webb and Yarborough.
Excuse me, Judge.
Ma'am.
It's Carly. Sorry. I'm sorry. Did you adjourn Mr. Waitkiss?
I did. I put him over to the 22nd at 1 p.m.
Thank you.
He applied with DHS on the 25th, but he hasn't done the 539.
Thank you very much.
Thank you, ma'am. Mr. Robinson. Two three zero three five. Good morning, Mr. Robinson. 2303578 LT Evergreen Town and Country versus Ron Webb. State your names for me, please.
Good morning, Your Honor. For the record, Steve Robinson, appearing on behalf of plaintiff.
Mr. Webb.
Yeah, I'm here.
State your name, sir.
Ronald Webb.
Thank you, Mr. Webb. Have you made an application for rental assistance?
Yes, I have. I've gone through DHS, Salvation Army, and United Way.
And when did you make those applications, sir?
DHS is the 24th of last month. Salvation Army and United Way, I just got a hold of them last week.
Have you received a response from DHS, Mr. Webb?
Yes, I have. DHS has denied me because I make a little too much money for them to help with the emergency relief. So they turned it over to Salvation Army and United Way.
Mr. Webb, were you advised that you need to file the form called the DC 539 to put the court and Mr. Robinson on notice that you made an application for rental assistance?
Yes, I have.
Did you file that form, sir?
No, ma'am, I have not.
Is there a reason why you have not, sir?
I got my ID stolen yet again. I've gone through these two cards this month. Every time I turn around, somebody's hacking into bank accounts and stealing money. And I've been involved in trying to track that down and stop that. In the past year, this handful of cards right here, every one of these has been hacked into, to include 4 bank accounts. This card
Mr. Webb,
right here was my last paycheck. I didn't get to see it on Friday. This is a brand new card. It was hacked into, and $747 was taken out from my paycheck.
Mr. Webb, what will happen is you need to file this form called the DC 539. It's required to put the court and the plaintiff on notice that you made an application for rental assistance. This is the second hearing in this matter. If you made your original application on the 24th of January, you should have filed that form within 5 days. So please file the DC 539. Your case will be adjourned to the afternoon, 1 p.m. on February the 22nd. That will be the last adjournment of this case. When you appear, you will need to provide an update regarding the status of your applications for rental assistance and be prepared to discuss how you are going to resolve this outstanding matter.
Believe me, Your Honor, I am trying. Every time I turn around, I'm a victim of ID theft or payroll. This is a brand new payroll card, and it was hacked into before I even got the card in my possession. I don't know how. I'm basically living with I'm working my tailbone off only for somebody else to steal my money from me as soon as it hits payroll.
Mr. Robinson, was there anything you wanted to say in this matter?
No, Your Honor.
Thank you. Mr. Webb, that notice will be mailed out to you to reappear on the 22nd at 1 p.m. And again, before you leave, sir, we'll move you into a breakout room. You'll speak to the clerk
Yes.
about how to get the DC 539 filed, okay? Thank you. This is a
Okay.
recall of 2303559 LT Maxwell versus Williams. Your appearances are already noted for the record. Ms. Williams, you had the opportunity to speak to Mr. Joseph.
Yes, ma'am, I did.
Mr. Joseph, how are we proceeding?
Judge, at this time, in our discussions in the breakout room, Ms. Williams indicated that she's having an issue with mold in her unit, mold in the bathroom and in a hallway closet, to which she had indicated that management had gone out and sprayed, and she's not satisfied with that. They haven't done a follow-up. This is the first I'm hearing about this information. And frankly, I don't see anything that supports this issue compromising habitability. We don't know what kind of mold it is. We don't know if the mold is due to the conduct of the tenant or if it's some other issue. And we also know that the landlord already went out there and treated the mold. I asked Ms. Williams about the balance, which is $4,623, whether or not she had placed any of that balance into escrow. She had indicated she has not, and that she doesn't have the ability to, she doesn't have that full amount on hand now anyway. At this point, I believe we should be able to move forward, but I'll leave it to the court's discretion.
Ms. Williams,
Yes, ma'am.
your response to what Mr. Joseph just said.
That's basic. Yeah, that's about correct, ma'am.
Did you stop paying rent because of this mold issue?
Yes, I did. They came and sprayed like a cleaning solution, like for a shower tile X, and then he told me to, if the mold, when the mold comes back, to just continue, like to spray it again to make it go away. But the mold just continued to grow aggressively across my entire ceiling in my bathroom. And then it started to spread into my hallway closet next to my bathroom. And I've made multiple requests for maintenance to come and get rid of the mold. And after the first time they appeared, no one came again. And the mold has just remained in our bathroom and in our hallway.
That Mr. Joseph, there was no indication in the file that this issue was raised at the first hearing with Judge Oakley on January 17th. What the court's inclined to do is schedule this matter for a hearing for you to have the representative from the Maxwell present, for Ms. Williams to appear with her documents and any witnesses she has necessary. And Ms. Williams, the court would grant what is typically a request for an escrow order in this matter. You would need to place escrow equivalent to rent with the court within the next 7 days. What is the monthly rental, Ms. Williams?
It's $1,296 a month, ma'am.
Mr. Joseph, hearing on this matter on the 22nd at 1:30 p.m.
Okay.
Will that give you sufficient time, sir?
That gives us enough time for sure, Judge.
Ms. Williams, are you prepared to have a trial in this matter
Yes, ma'am.
on the 22nd at 1:30?
Yes, ma'am.
Ma'am, you'll be responsible to this, Zoom or in person, Mr. Joseph?
It should just be testimony from the client from our side. So, I mean, I think Zoom is sufficient, but there's nothing for us to supply the court as far as exhibits go.
Ms. Williams, do you have a preference?
No, I do not have a preference, no, ma'am.
Okay, we'll do it on Zoom. Mr. Joseph will have the screen share available to you. Ms. Williams, you'll be responsible. The court will enter escrow order. You'll be responsible to deposit $1,296 with the court within the next 7 days. You'll be responsible to appear on the 22nd at 1:30 p.m. with all necessary documents and witnesses to support your claim that your use of the space is diminished by this condition that you have indicated on the record. Was there anything besides the mold in the bathroom and the closet that you allege is the reason why you stopped paying rent, Ms. Williams?
No, ma'am.
Anything else, Mr. Joseph?
Nothing further. I just want to clarify, do you need us to submit an escrow order, or will the court just enter it?
We'll enter it. Carly, make a note. We'll do the escrow order.
Yes, Judge.
Thank you, ma'am. Anything else, Ms. Williams?
I just had a question about the escrow. So do I go myself? Do I go and look that up and put money into the escrow, or is there going to be like documentation sent to me or something?
There will be an order that the court enters, but you'll come put it on deposit with the court.
Yes, ma'am. Okay.
Okay.
Yes, ma'am.
Anything else, Ms. Williams?
No, that's all.
I'll see you on the 22nd, ma'am. You have a good day.
Thank you. You
Thanks,
too.
Judge, have a good day. Thank you.
You too, sir. Thank you.
Thanks.
2303576 LT Evergreen Town and Country versus Kayla Brown.
Good morning again, Your Honor. For the record, Steve Robinson appearing on behalf of the plaintiff.
Good morning, Kayla Brown.
Thank you. Today is the day and time scheduled for the second hearing in this matter. Ms. Brown, have you made an application for rental assistance?
Yes, ma'am, I did. I applied on the 16th of last month. I just got a call back from DHS yesterday, but I was at work, and by the time I got off at 3, they were closed already, and they didn't open again till 9 this morning. So my plan is to call them as soon as I get off with you guys.
Ms. Brown, were you advised that you needed to complete and file with the court the DC 539 to put the court and the plaintiff on notice that you've made an application for rental assistance?
To be honest, I do not remember if we talked about it. I have a paper right here. I don't know if you're going to be able to see it to find out if this is what I'm supposed to file or not. I'm sure
Yes,
you probably
ma'am.
can.
That is
it?
what you're supposed to file. Yes, ma'am.
Okay. All right. So do I have to go to the courthouse to file this, or can I fax it, or?
You can file it electronically, Ms. Brown, and before you leave, we can move you into a room. There's a gentleman from the clerk's office who can talk you through that process. But ma'am, that will be the final adjournment of this case to the afternoon of the 22nd, 1 p.m. on the 22nd of February.
Okay.
You need to file that 539 sooner rather than later. The hearing on the 22nd will be an update regarding the status of your application for rental assistance, along with how you'll resolve the outstanding balance in this matter, okay?
Judge,
yes, ma'am.
Was that 1 o'clock?
It is, sir.
And my
Court staff
client,
will mail notice. I'm sorry.
oh, my client's on too. I just want to verify he got that information. Rick, did you get that?
Yeah, I got it.
Okay. Thank you, Judge.
Thank you.
Thank you. Ms. Brown, we'll move you in with Malachi. He'll help you get that form filed. You don't need to appear in person to do that.
All right. Thank you so much.
Thank you, ma'am. Mr. Robinson, is that it for you, sir?
That's it. Thank you, Judge. Good seeing you.
Thank you. Good to see you. Mr. George and Ms. Becker.
Good morning.
Good morning.
Good morning. Are you looking to do intake this morning, or are you here with an appearance on some case?
We're here for intakes this morning. I do have a case coming up at 11:30.
Marianne, I don't know when people have been checked in, if you're asking if they want to speak to Lakeshore.
No, ma'am, I have not.
Mr. George, was your office here on the first docket? With Judge Oakley would have been the 17th of January. The cases with me would have been from the 24th and the 26th.
I'm not sure offhand, Your Honor.
Okay. I'll be more mindful to ask people then as we proceed through the docket.
Thank you, Your Honor.
Thank you. Ms. Brown, there's already an invitation for you to go in with Malachi. Please go there.
Okay, thank you.
Thank you. This is a recall of 2303566 LT Holiday Woods versus Webb and Yarborough. The parties
Yes.
have had the opportunity to speak. Ms. Coolsey, how are we proceeding?
Yes, Your Honor. We did come to an agreement. It's a consent judgment. Rent to retain is $2,604. Cost of $246.29 for a total balance of $2,850.29 to be paid on or before February 19, 2024. I did advise them of their rights under MCR 4.201J, and they've also given me consent to sign their name to the judgment.
Thank you. Ms. Coolsey, the only adjustment that I'll ask you to make is that date will be the 20th. We're closed on the 19th.
Yes, Your Honor.
Mr. Webb and Ms. Yarborough, you were able to hear Ms. Coolsey just now?
Yes.
And it's your understanding and agreement that a consent judgment will enter showing rent due of $2,604. I'm sorry. Yes. Cost of $246.29 for a total judgment of $2,850.29.
Yes.
And that's what you want to agree to.
Yes.
And when you were here back on January 17th, you saw a video that explained your legal rights in this landlord tenant matter.
Yes.
And you also received with your summons and complaint an advice of rights form that explained those rights in detail.
Yes. Yes.
And you wish to waive your rights to have a hearing in this matter and enter the consent judgment with the terms just placed on the record.
Yes.
Before the court accepts the terms of the consent judgment, do you have any questions about that consent judgment or today's proceedings?
Next question. So with the consent judgment, just making the payment before the 20th, everything will be fine? Like, will there be another hearing as long as we make the payment or no?
There won't be another hearing. The consent judgment will say that you will pay this amount
Okay.
or vacate the property by by February 20th. If you don't pay it, then the plaintiff, we won't have another hearing, but then the plaintiff would have to come back to the court to file new paperwork to ask to have you removed from the property for failing to make payment.
No, that was all.
Did that answer your question?
Yes.
Did you have any other questions?
No, not right now.
Thank you. Well, now's the time.
No, it's okay.
Okay. The court will accept the consent judgment. Ms. Coolsey's office will prepare it, sign it on your behalf, file it with the court electronically. You will receive a copy in the mail. You have a good day. Good luck to you.
Thank you, Your Honor.
So, Marianne, okay.
Hey, Judge.
Yes, ma'am.
So I'm dispoing these right now, and I went to schedule, and it's telling me that your entire day is blocked off for the
No.
22nd.
I'm sorry, 1 second. I'm sorry, Carly, what did you say?
Your entire day is blocked off for February 22nd is what I'm showing. I just went to
It's
schedule them.
blocked off. No, I moved a docket, but I'm in Lansing in the morning. Unless you know something I don't know.
No, I don't. It's just not letting me schedule them for one.
Okay, I don't know is it Mariah that I need to talk to?
I can let her know and see if she can get it opened up.
Okay, that's what it was, I
Okay.
think.
Thanks.
Thank you, ma'am. Is that what it was? What was originally scheduled? Huron? This is 2400290 LT Parkwood Manor versus Denisha Hardman.
Good morning, Your Honor. Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Hello,
State your name, ma'am.
Danisha Hardman.
Ms. Hardman and Ms. Sprague, the last time the parties were here, it was the request was to adjourn the matter to review the ledger. Were the parties able to do that, or do you need to do that this morning?
I already spoke with my landlord and we resolved the problem, so everything is fine now.
If it's possible to speak in a breakout room, Your Honor, I believe we can enter into a conditional dismiss.
Would you go into the breakout room, please?
I'm at home, so I don't.
Oh, no, ma'am, there'll be a button that directs you into another virtual room to discuss the case. Mary Ann, I saw your note. I'm gonna step off to attend to that. I'll be right back.
Is the court on a recess?
What happened to Ms. Hartman?
She was back here. I don't know, Judge. She was back on screen.
Uh, hmm. We're still on the record in 2400290LT. Did you have the opportunity to speak to Ms. Hartman? You're muted.
Thank you, Your Honor. I did, and we have terms for a conditional dismissal we were going to place on the record. If it's possible, I will try to reach her via phone and have her log back in.
Thank you, ma'am. I'd appreciate that.
Thank you.
Good morning, Ms. Simpson.
Good morning.
We're preparing for a second hearing in this matter. Ma'am, would you like the assistance of legal aid this morning, Lakeshore Legal Aid?
Yes, please.
Have you made an application for rental assistance?
I have.
Who did you make that application with, ma'am?
MDHHS, excuse me.
When did you do that?
I did that on the 24th of January.
And did you file this form that's called a DC 539 with the court?
I believe so.
Okay, and my last question before we move you in for screening with Lakeshore is the other Simpson there with you, or are they logging on?
They are logging on right now.
Okay, then what we will do is get you moved into a breakout room to meet with Lakeshore Legal Aid. We have not seen the attorney for Farmington yet. And when the case is recalled, you will need to be able to turn your video on, okay?
Yes, ma'am.
We'll get you moved into a breakout room with Lakeshore. Miss Anderson.
Good morning.
Good morning. I'm not quite ready to call your case yet. I just wanted to check to see if you wanted to speak with Lakeshore Legal Aid this morning.
No, not this morning.
Okay. And there was a clerk here for pallets earlier. Let's see if they're in I don't see them right this second, but sit tight.
Okay.
Your case is scheduled at 10 o'clock. When they pop back on, we'll get you connected with them, okay?
All right. Thank you so much.
You're so welcome. Miss Jones, good morning. You're muted. Let's get you unmuted.
Good morning.
Good morning, ma'am. Before I call your case, the attorney is here for Parkwood, but I wanted to check with you to see if you wanted the assistance of Lakeshore Legal Aid this morning.
Yes.
Have you made an application for rental assistance?
Yes, ma'am, I have.
And you applied with what agency, ma'am?
MDHS, MDHDS, or something like that, through the state.
When did you make that application, ma'am?
It was last week. I want to say last Monday or Tuesday.
Did you file the form DC 539 with the court?
No, ma'am, I'm not even for sure what that is.
It's a form that puts the court and the plaintiff on notice that you have made such an application for assistance.
Okay. No, ma'am, I wasn't aware of it. I didn't do it.
It's fine, Ms. Jones. What we'll do, we'll get you moved into a breakout room for screening with Lakeshore Legal Aid when you come out. We'll get you connected with the attorney for your complex, okay?
Okay, thank you so much.
You're so welcome. Were you able to get a hold of Ms. Henderson? Ms. Hardman?
Ms. Hardman, it went straight to voicemail. With your honor's permission, we'd like to wait until after our 10 o'clock hearings, if that's okay, and possibly have this recalled.
Absolutely.
Okay, thank you. And I'll continue to reach out as well. I think your phone may have just died.
Okay. Courtney Fickling.
Yes.
This is 2303635 LT Parkwood versus Fickling, ma'am. Please state your name for the record.
Courtney Fickling.
Ms. Fickling, the last time we were here, you indicated that you made an application for rental assistance. The court did receive the 539. Have you received an update or payment from DHS?
Yes, I did get approved for $620. And I also am starting a payment plan with my apartment.
Ms. Sprague, was there a resolution that needs to be placed on the record, or do you need a moment with Ms. Fickling?
If I could have a moment in a breakout room, I just want to confirm the terms in that $600 payment.
Absolutely. Marianne will get you moved.
Your Honor. This is George from Lakeshore.
Yes, Mr. George.
I was just wondering, like logistically, is it your intention that those folks that asked to speak with us, is it your intention that you're going to call their case again after they speak with us?
I would like to, because these are second hearings. If you need more time to do intake, or if there's something else, what would work for you?
Yeah, well, I was just thinking because typically our screening takes about 20 minutes, and then for the attorney to give advice is another 20 minutes, and I don't necessarily want to clog up your docket if you're waiting to recall these cases. I'll leave it to your
Mr.
discretion how
George,
you want to handle it, but
my docket goes until 2:30 today, so it's not clogging up my docket, and I'm sure that the attorneys who are here can hang around for a little while. These are, I think, the people that wanted to speak to you are applying for assistance anyway, which would put them over for the 539 to be filed and an update regarding their application. So we will be going over to the 22nd.
okay.
So take your
Obviously,
time, and then when you come back out, we'll.
okay, gotcha. Thank you.
You're welcome. And if something changes, we'll pull you back into the session.
Okay. I'm going to hang out here
Thank
in the
you.
main session. We've got attorneys in with
Oh.
the 2 intakes we've got right now. So
Okay.
thank you.
Thank you, sir. Two three zero three six four one LT. This is Holiday West versus Anderson. What happened to Miss Anderson?
They're in a breakout room. Do you want me to pull her out?
No. Oh, Miss Kuzi popped back on. I didn't realize that she was in with the law clerk from the firm. Okay.
Hello, Your Honor, Sandra Kazan on behalf of plaintiff.
No, Miss Anderson's in with your law clerk, so
Showing them.
I think that was it until 10:15. I don't know that we've seen any of your 10:15s yet.
Thank you.
Good morning, Mr. Munson.
Good morning.
On the Simpson matters, they're in speaking with Lakeshore Legal Aid. If you want to sit tight for a little bit.
Okay. All right. Thank you.
You're welcome. Two three zero three six four one LT Holiday West versus Anderson. Please state your names for the record.
Alicia Anderson.
Sandra Cruz on behalf of plaintiff.
Thank you. Today was the day and time scheduled for the adjourned hearing in this matter. Parties have had the opportunity to speak. How are we proceeding?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $3,572.61. Cost of $190.24 for a total amount of $3,762.85 to be paid on or before February 20, 2024. I did advise her of her rights under MCR 4.201J, and she's also given me consent to sign her name to the judgment.
Ms. Anderson, were you able to hear the attorney just now?
Yes.
Was everything she said true and accurate?
Yes, ma'am.
Ma'am, what's the status of your DHS application?
It was denied.
And Ms. Anderson, when you were here back on January 24th, you had the opportunity to review the video that explained the rights you had available in this landlord tenant proceeding.
Yes, ma'am.
And you also received a copy of the advice of rights with the service of the summons and complaint.
I believe so.
And ma'am, you wish to waive the rights you have available and enter a consent judgment with the terms just placed on the record.
Yes.
Do you have any questions at all about those rights or today's proceedings?
No.
Then the court will accept the terms of the consent judgment that were just placed on the record. Ms. Cooley's office will prepare it, sign it, submit it to the court electronically. You should receive a copy in the mail in a few days. Is there anything else in this matter, Ms. Cozy?
No, Your Honor. Thank you.
Anything else, Ms. Anderson?
No.
Good luck to you, ma'am. That concludes this matter. You're free to go. You have a good afternoon.
Thank you. You all have a wonderful day.
Thank you. Ms. Simpson. This is a recall of 2303306 LT. You have the opportunity to speak to the representative from Lakeshore.
I did.
Mr. Munson is here. How are we proceeding?
Lakeshore is not able to assist.
Okay. Mr. Munson. Mr. Munson. I'm not sure what happened to him. Ms. Jones, you had the opportunity to speak to Lakeshore Legal Aid.
Yes, ma'am.
Are they going to be assisting you in this matter?
Unfortunately, they're not going to be able to.
Then this is a recall of 2303636 LT Parkwood versus Jones.
Okay,
Ma'am, you indicated that you made an application with DHS back on January 30th or so.
yes, ma'am.
Ma'am, were you advised that you need to file the form called a DC 539 with the court?
No, ma'am, I'm not aware of what that is.
Okay, then ma'am, before you leave today, when you go out that door on your left, go around the corner, go to the civil department, you can complete that form, submit it. It puts the court and the plaintiff on notice that you've made an application for rental assistance, okay?
Okay, and it's called a what? What's the form? They'll know what I'm talking about when I get to the desk?
They'll know what you're talking about.
Okay.
It's called DC 539, but you'll tell them that you just come out of the courtroom with me,
Yes, ma'am.
that you need to file the form. They'll know what it is. There's
Okay.
civil department staff on this Zoom proceeding just now, right now.
Okay.
Ma'am, the court will adjourn the matter over to February the 22nd at 1 p.m. When you appear on that date, you will need to provide an update regarding the status of the status of your application for rental assistance.
Okay. And you say, excuse me, Judge, you said February the 22nd?
At 1 p.m.
Okay, at 1. Okay, because I'm writing this down. Yes, ma'am, I got it.
Okay, was there something on behalf of Parkwood?
We would just like to note for the record that there is currently over $8,000 due and owing. If Ms. Jones has only applied for DHHS, we would highly encourage her to make applications to other agencies, as it's unlikely to be sufficient to cover the whole balance.
Okay.
Anything else, Ms. Jones?
No, ma'am, that was it.
Anything else on behalf of Parkwood?
No, Your Honor.
Ms. Jones, if you exit out that room through the door on your left-hand side, just go around the corner, that counter. Someone from the civil department will be there. You just need to submit that DC 539.
Okay.
Thank you, ma'am.
Thank you.
Mr. Munson, I saw your note. This is 2303306 Farmington versus Simpson and Simpson.
Good morning, Your Honor. Thank you for your patience. Grant Munson on behalf of the plaintiff.
Would you state your name for the record, ma'am?
Sharon Simpson.
And the other Ms. Simpson?
Janine Simpson.
Turn your video on for me, please, ma'am. Today is the day and time scheduled for the adjourned hearing in this matter. Ms. Simpson, number 2, has indicated that there has been an application for rental assistance through DHS. Would you like the opportunity to speak to Mr. Munson this morning?
Yes, please.
Let's get them moved into a breakout room.
Thank you, Your Honor.
You're welcome. What happened to Miss Fickling? Ms. Sprague?
Yes, Your Honor.
Did you speak to Courtney Fickling?
I did, Your Honor. And
okay, let's
she was still,
get them
yes,
I see them still out in there, and I wasn't sure if you needed something else in the breakout.
Oh, no, my apologies. I've moved her in.
No worries. This is a recall of 2303635 Parkwood versus Fickling. Please state your names for the record.
Courtney Fickling.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Thank you. The parties have had the opportunity to speak. How are we proceeding this morning?
Your Honor, we would like to enter the terms for a conditional dismissal on the record. We do show that currently there is past due rent in the amount of $1,519 with court costs of $213 for a total due and owing of $1,732. Beginning on February 16th of 2024. Defendant has agreed to pay $100 every 2 weeks to plaintiff until the past due balance listed in 2D above is paid in full. Plaintiff will accept and apply any payments made by SER to the balance due in 2D. Defendant currently has a $0 portion for rent for February of 2024, but per the Westland Housing, the tenant rent beginning on March 1st of 2024 will be $322. Future rent will be due by the 5th of each month, in addition to the payment on past due. Failure to pay as agreed upon will result in a default of this agreement, and that is with box 4B and box 7 check.
Thank you. Ms. Fickling, you were able to hear the terms just placed on the record regarding the conditional dismissal.
Yes.
And that's the agreement you wish to enter.
Yes.
When you appeared back on January 24th, you had the opportunity to review the video that explained the legal rights you had available in this landlord-tenant matter?
Yes.
And you also received a copy of the advice and rights when you were served with the summons and complaint?
Yes.
And you understand the rights you have available this morning?
Yes.
And you wish to waive those rights and have a conditional dismissal enter with the terms just placed on the record?
Yes.
Do you have any questions about today's proceedings or the rights available to you?
No, ma'am.
Then the court will adopt the terms of the conditional dismissal just placed on the record. The plaintiff's office will prepare it, file it with the court electronically. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of the plaintiff?
Do I have authorization to sign the defendant's name?
Ms. Fickling?
Yes.
Any questions, Ms. Fickling?
No, ma'am.
That concludes this matter, ma'am. You're free to go. You have a good day. Good luck to you.
You as well. Thank you.
Thank you. I see the parties are back in 2303306 Farmington versus Simpson and Simpson. Your appearances are already noted. You've had the opportunity to speak. Mr. Munson, how are we proceeding?
Your Honor, we'd like to enter into a consent judgment for a total balance inclusive of all costs and fees of $7,880 to be paid on or before February 20th of 2024, or a writ of eviction to issue.
Mr. Munson, my only issue and concern with that is that Ms. Simpson indicated on the record that she had made an application for rental assistance through DHS.
That was on the 7th, Your Honor, and it was I apologize. That was at our last hearing, and it was stayed to this date because of that. So the DHS stay was from our hearing on January 24th.
Maybe I'm misunderstanding the new court rule. I thought the stay was 14 days. At the adjourned hearing, there was an update, and if the application was still pending and the defendant's tenants provided an update, it could be stayed for an additional period of time. Is that your understanding of the court rule, sir?
You know, honestly, I don't understand the court rule, and I know that every court is handling it differently. So I don't know, to be completely honest. I don't know. I thought that there's one stay of 14 days and then it's done, unless it's, granted. But I'm not going to stand before the court and tell you I'm 100% sure.
Well, that's why I keep a copy of that court rule out, and it is 3B, and it indicates the stay is lifted after 14 days unless the defendant demonstrates to the court that the application is still pending or has been approved and rental assistance will be received. Ms. Simpson, what is the status of your application with DHS, ma'am?
Sure. Thank you for asking. It has been denied.
It has been denied?
It has.
Thank you. I just want to make the record clear. Thank you, Ms. Simpson. Mr. Munson, it having been denied, that means that the stay is lifted and the court is prepared to enter the consent judgment. Ms. Simpson, you heard the terms that Mr. Munson placed on the record indicating that $7,880 in rent is due and that you will pay this amount or vacate by February 20th.
Correct.
And that's your full understanding of this matter?
Yes.
And you've received the advice of rights form that explain the rights you have available in this matter?
Yes.
And the other Ms. Simpson, you were present back on January 24th, and you had the opportunity to review the video explaining the rights you have available in this landlord tenant matter.
Correct.
And you understand those rights and you're waiving those rights.
I understand.
And before the court adopts the terms of the consent judgment, both Ms. Simpsons, you understand the rights you have available and you understand your rights in these proceedings.
Yes. Yes.
And you wish the court to enter the consent judgment.
Yes. Yes.
And have you authorized Mr. Munson to sign your name to the consent judgment with the terms?
Yes. Yes. Sorry for my delay.
Thank you. No worries. Then the court will adopt the terms of the consent judgment placed on the record by Mr. Munson. He will sign your names to it, submit it electronically, and a copy will be mailed to you at the address we have on record. Mr. Munson, is there anything else on behalf of your client?
No.
Either Ms. Simpson, anything else?
No, not at the moment. No, Your Honor.
Thank you. Then the court will wait receipt of the document from Mr. Munson. This matter is concluded. You're free to go. You have a good day.
Thank
you, Your Honor. Have a nice day.
Have a nice
You
day.
too. Thank you. This is 2303653LT. This is Holiday West versus Monica Washington.
Hello, Your Honor. Sandra Guzman.
Yes. I'm here.
Miss, state your name, ma'am.
Monica Washington. I'm sorry, it's a delay.
I know, it's fine. Miss Washington, today is the day and time scheduled for the adjourned hearing in this matter. The last time we were here, you indicated that you made an application for rental assistance and you submitted the form to the court. What's the status of your application for rental assistance, ma'am?
My worker called me on Friday and she needed a 6-month ledger from Holiday West, also with their provider ID to make a determination. They just gave me that on Monday. I uploaded it last night upon my arrival home. So I'm just waiting for my worker to make a decision. She has everything that she requested.
That being the case, Ms. Washington, this case will be adjourned one last time to February the 22nd at 1:15 p.m. on that date. The court will be prepared to enter a judgment or dismissal, conditional dismissal of this matter. You'll need to provide an update regarding your application for rental assistance and how you intend to resolve this non-payment of rent case, okay?
So they actually have a payment from me. We're just waiting to see if the state would cover it because my worker told me to tell them don't process the payment. They have the full payment of $22,211. But if I had a copay, I would have still had to pay the copay and whatever the state was going to pay. So they just told my landlord to hold on to that check. So before they went ahead and actually cashed it. So if I had a copay, the copay would already be covered, but they have the full amount of what I owe.
Ms. Kuzi?
Yes, Your Honor. I have not been advised that a payment was accepted by my client. However, if you could just put us in a breakout room and I can just discuss this matter.
Absolutely. She'll be there a moment. Ms. Washington, we'll get you moved into a breakout room. Ms. Kuzi will be there momentarily.
Okay.
She has just a few other matters I need to call.
Okay, that's fine.
Thank you. 2303646 LT Holiday West versus Long.
Sandra Cruz on behalf of the plaintiff.
What happened to Miss Long? I just saw her. I just saw her. I don't know what happened to her.
This might be her coming back in, Judge. I believe that's her.
Sorry,
Ms. Long, state your name for the record.
Angelique Long.
Ms. Long, what is the status of your application for rental assistance?
It has been approved. I have to wait until next Wednesday when I get paid to show her proof of what I'm paying, and then she'll pay the rest.
Ms. Long, we'll get you moved into a breakout room with Ms. Coolsey. You have the opportunity to speak to her. When you come back out, we'll figure out how we're proceeding, okay?
Okay, thank you.
Thank you. Ms. Pickett, 2303648 LT, Holiday West versus Lavonda Pickett and Deshante Henderson.
Yes, this,
Ma'am, state your name, please.
Lavonda Pickett.
Ms. Pickett, where is Henderson? Do you know?
No, she's at work, so she should be getting online.
I don't see her, but we'll get back to that. Do you know what the status of the application for rental assistance is?
Well, my daughter, she did the application, but the total amount that we owe Holiday West, it is paid. I made the last pay. I put the last payment in the Dropbox Sunday, and I talked to, I can't remember the lady name that I talked to yesterday, and they did she did receive the 514 that was left that I owe, because I already gave 1,070 on the, I think the 24th or the 25th. And then I gave the rest of it, put in the Dropbox Sunday when I got off of work.
Then Ms. Pickett, we'll get you moved into a breakout room. You have the opportunity to review that with the attorney. You'll be able to check to see the status of the payment from Sunday, okay?
Yes, ma'am.
Thank you. 2400070 LT, Belleville Point versus Robert Lee.
Good morning, Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
Good morning, Ms. Cohen. It has been quite a while.
Yeah.
This case was scheduled at 10:15. It's now 10:26 by this court's clock. Mr. Lee. My policy is about 15 minutes after the scheduled start time. I'm not hearing a response, but I see a few people unnamed in our breakout rooms. And there's someone coming on, so if you could sit tight for about 3-4 more minutes.
Of course. Thank you so much.
Thank you. The person that just joined us on the phone, your name, please?
Tamiko Kennedy.
Ms. Kennedy, your case is scheduled at 10:30. Is there a reason why you're not on Zoom with a video?
Yeah, I'm in a really bad area and my connection is bad. Hello?
I'm here, ma'am. We'll get you moved into a breakout room to discuss the case with the landlord. Were you looking for the assistance of Lakeshore Legal Aid this morning?
Could you repeat that?
Were you looking for the assistance of Lakeshore Legal Aid, the attorneys who might be available to at least provide advice to you in this matter?
No, I just would like to speak to the landlord.
Okay, we'll get you moved into a breakout room to talk to a representative from the Palace Law Firm. Ms. Henderson, we're going to get you moved into a breakout room. Somebody will get you relabeled. We're going to mute you and get you moved in with Ms. Pickett, okay?
Okay.
Thank you. Carly?
Hi, Judge, it's Sandy.
Oh, Sandy, okay. There was someone in your breakout room that was labeled as connect with audio.
She's up here
Thank
now.
you.
Do you need her, do you need me to take her into a breakout room to see if I
No.
can?
Ma'am, what is your name, please? With the black jacket on?
I'm sorry.
Ma'am, with the black jacket, it looks like you're in a mall or a store. Ma'am, your name with the red nails. Yes, ma'am, you. Mm-mm. Ma'am. Mm-mm.
That's Monica Washington, ma'am, or Judge.
Nope. I'm trying to get the guy with the black shirt because if that's not Mr. Lee, I can get Miss Cohen on her day. This never stops being fun.
Hello?
Wonderful. Your name, sir?
Sorry, Jeffrey Stringer.
Mr. Stringer, we're gonna get you relabeled.
Okay.
Your case is scheduled at 10:45. There's some other things that the court needs to address first. Give me one moment. 2400070 LT Belleville Point versus Robert Lee. The case was scheduled at 10:30. It's now, I'm sorry, 10:15. It's now 10:34 by the court's clock. There are no unidentified persons in this course session. Ms. Cohen, how would you like to proceed?
I'm requesting a default judgment, Your Honor. There's currently $2,837.65 owed in rent, $175.54 in court costs, for a total of $3,013.19, with the writ to issue after I believe the 19th is a holiday, so that would be the 20th, February 20th, 2024.
Thank you. Defendant having failed to appear as directed by this court, default judgment will enter with the terms just placed on the record. Ms. Cohen, if you would have your office file that on unbased, the court will sign it. Anything else this morning, ma'am?
No, thank you so much. Have a wonderful day.
You too. Thank you, ma'am.
Bye-bye.
Ms. Washington, did you finish your conversation with Pallett's Law Firm? Ms. Washington? No, ma'am, I can't hear you. Ms. Mary Ann, were you able to talk to her in the breakout room?
No, I was not. I was chatting with her.
Ms. Washington?
Your Honor, I believe she's on Zoom twice, because there is a Monica Washington currently in the Attorney Pallett's meeting room. So I think she's speaking with the attorney right now.
Oh, for the love of mankind. Thank you, Mr. George.
You're welcome.
Oh, it's a wonderful Wednesday. No luck with Ms. Hartman?
No, Your Honor. And while I don't have authorization to request a 2-week adjournment because I haven't been able to reach my client either, we would not object if the court deemed it appropriate to give a 2-week adjournment. If at all possible, on February 22nd at 1 o'clock, and we'll be returning for another case.
Actually, it'll be 1:15. This is 2400290 LT Parkwood versus Hartman. We'll make a note for the record that Ms. Hartman was here, did speak to the attorney for Parkwood, disconnected and has not returned. If she does not return on February 22nd at 1:15 p.m., the court will take it as a default. Other than that, was there anything, Ms. Bragg?
Your Honor, if we are able to obtain a signed conditional dismissal, do you still require that Ms. Hardman appear in person on the 21st?
No, ma'am. You can sign it, submit it through On Base, and I'll sign it.
All right. Thank you very much. Have a great day.
Thank you. You too. Oh. Miss Norris, 2400176 Harbor Club versus Norris.
Your Honor, for the record, Attorney Ian Morton of Palace
Hello.
on behalf of the plaintiff.
State your name, ma'am.
Nayla Norris.
Thank you. Today is the day and time scheduled for the adjourned hearing in this matter. Ma'am, have you made an application for rental assistance?
So that's why I was just talking in the meeting with I forgot the person's name, but when I was in the meeting, I was telling him that I had troubles trying to access the application. Maybe I don't know if it was like the website or something, but I had trouble, so I was just gonna ask for some guidance.
Mr. Morton, were you speaking to Miss Norris?
No, I believe that was Miss Cousy.
Oh, she said a man.
Were you? Well,
I'm
Miss-
sorry. I'm sorry. I'm sorry. It was a woman. I'm sorry.
Oh,
So I'm sorry, Ms. Norris, so you're saying that between January 24th, when you were last here, and today, that you've not been able to make an application?
Correct. It was more not the application, but I haven't been able to. I don't know what it is. I haven't been able to access the website.
Ma'am, would you like the opportunity, if you already spoke to an attorney from Palace Law Firm?
Not today. I don't think so.
I was going to say.
Would you like the opportunity?
Go ahead.
No, you go ahead.
I was going to say, Your Honor, it sounds like she had spoken to Miss Cousy maybe previously beforehand. If you'd like to call this, and maybe Mr. Stringer, I can talk to the parties in the breakout room.
Thank you. Miss Norris, we'll get you moved into a breakout room. You have the chance to speak to Mr. Morton from Palace Law Firm. There's a couple other cases I'll get moved in there too. But we'll get you moved into his waiting room for right now. He'll be in there momentarily to speak with you, okay? There was 2400085 LT Rawsonville Woods versus Letice Jordan.
Hello, Your Honor.
Today's the day and time scheduled for the adjourned hearing in this matter. The last time you were here, ma'am, since the last time you were here, you submitted a copy of your STR application. Have you received a response or update from DHS?
There has been no update as of yet, Your Honor. I'm still waiting to hear back from them.
Let's get you moved into a breakout room to speak with Palace Law Firm. Did you want the assistance of Lakeshore Legal Aid this morning?
No, that would be, it'd be fine. I'm fine. Thank you.
You're welcome. We'll get you moved into that space. And then the last one, 2400181 LT Harbor Club versus Stringer.
Yes, hello.
Mr. Stringer, you made an application for rental assistance and you filed the 539 with the court. Do you have an update regarding your application for assistance?
I do not. I haven't heard anything. I checked my email this morning before I logged in here, and I have not heard anything back yet.
We'll get you moved in with Mr. Morton, and Mr. Morton, if you would talk to those three persons,
Absolutely, Your Honor.
and then I'll recall the cases when you come back out. Thank you.
Thank you.
Ms. Robinson, 2303650 LT Holiday West versus Robinson.
Yes, hi. Hello, this is Donita
Hi.
Robinson. Hi.
Thank you. The last time we were here, you were going to make an application for rental assistance. Do you have the status of that application?
Yes, I just got denied.
Would you like the opportunity to speak to someone from Palace Law Firm representing Holiday West?
Yes,
We'll get you into a breakout room.
thank you.
Thank you. Marianne, is someone else still in the room labeling tenants, asking them if they want rental, legal assistance?
Yeah, Malachi's in there.
Did you tell him that we need to screen for that as well so that we can get those people directly connected to Lakeshore?
I will.
This is a recall of 2303648 LT Holiday West versus Pickett and Henderson. The parties have had the opportunity to speak. How are we proceeding this morning?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $1,012.28. Cost of $248.20 for a total amount of $1,000.
I'm sorry. Ms. Henderson. Ms. Henderson?
How you doing? Okay. Welcome.
Ms. Henderson. Ms. Henderson? Cost of $248, I'm sorry.
Yes, you're right. A cost of $248.83 for a total amount of $1,261.11 to be paid on or before February 20, 2024. I did advise them of their rights under MCR 4.201J, and they have also given me consent to sign their name to the judgment.
Ms. Pickett, were you able to hear Ms. Cousy just now?
Yes, ma'am.
And ma'am, you had the opportunity to view the video that explained the rights you had available to you in this landlord-tenant matter?
Yes, ma'am.
And you received that advice in writing when you were served with the summons and complaint?
Yes, ma'am.
And you wish to enter the consent judgment that was just placed on the record?
Yes, ma'am.
Ms. Henderson, same question. You were able to view the video that explained the rights available to you in these landlord-tenant proceedings when you appeared back on January 24th?
Yes.
And after having had the opportunity to review that video and receive the advice of rights in writing, you wish to enter the consent judgment that was just placed on the record?
Yes.
Ms. Pickett, do you have any questions about the rights available to you or today's proceedings?
No, ma'am.
Ms. Henderson, do you have any questions about your rights available or today's proceedings?
No.
The court will adopt the terms of the consent judgment placed on the record by Ms. Cousy. Her office will present that to the court electronically. I will sign it, and Ms. Pickett and Ms. Henderson, copies of that consent judgment will be mailed to you at the address we have on record. If there's nothing else, that concludes this matter. You're free to go. You have a good day.
Thank you. You too.
Thank you, Your Honor.
Thank you.
I don't have any clue.
This is a recall of 2400181 LT Harbor Club versus Stringer. Your appearances, please.
Your Honor, for the record, Attorney Ian Morton, Palace Law, on behalf of the plaintiff.
Mr. Stringer, you had the opportunity to speak to Mr. Morton.
Yes, Your Honor.
Mr. Morton, how are we proceeding?
Here, the parties did speak and have agreed to enter into proposed consent judgment agreement. Rents retained, $3,483.00. Court costs of $190.24, for a total of $3,673.24. As discussed, I did advise him of his rights. Was it specifically of the fact that this agreement is not final for 3 business days? Second, the fact that he has the right to appeal this decision on the next court level. And third, he did give me permission to sign his name to the proposed consent judgment agreement, which we would then submit to the court.
Thank you. Mr. Stringer, you were able to hear Mr. Morton just now,
Yes, Your Honor.
and everything he said is true and accurate.
Correct. Yes.
And you were here on January 24th, and you had the opportunity to view the video that explained the rights you had available to you in this landlord-tenant matter.
Yes, Your Honor.
And having seen that video and received a written copy of the advice of rights form, you wish to waive the rights available and enter a consent judgment with the terms he just placed on the record.
Yes, ma'am.
Do you have any question about today's proceedings or the rights available to you?
No, ma'am, I don't think so.
Thank you, Mr. Stringer. The court will adopt the terms of the consent judgment just placed on the record. Mr. Morton's office will file that consent judgment electronically. The court will sign it and a copy will be mailed to you at the address we have on record. That concludes this matter, Mr. Stringer. You're free to go. You have a good day.
All right, thank you. You too, Your Honor.
Thank you. This is 2400089 LT Rawsonville Woods versus Felicia Matthews. Please state your name for the record.
Felicia Matthews.
Your Honor, I don't believe I had a chance to speak with Ms. Matthews. I did speak with Ms. Letice Jordan, though.
Okay. Ms. Matthews, would you like the opportunity to speak to a representative from Rawsonville Woods?
Yeah.
We'll get you moved into a breakout room. Someone will be there shortly to discuss this case with you. This is 2400085 LT Rawsonville Woods versus Letice Jordan. Ms. Jordan, you had the opportunity to speak to Mr. Morton.
Yes, I did.
Mr. Morton, how are we proceeding?
Your Honor, the parties did speak and did enter into a proposed consent judgment agreement. Rents retained are $5,035.10. Court costs of $190.24. For a total of $5,225.34. I did advise her that the fact that this agreement would not be final for 3 business days, as well as the fact that she does have the right to appeal this to the circuit court the next 10 days. And additionally, she did give me permission to sign her name to the proposed consent judgment agreement.
Ms. Jordan, what happened with your application for rental assistance?
It's still pending.
Mr. Morton, does the fact that the application is still pending entitle Ms. Jordan to an additional say in these proceedings?
I thought there had to be another document that had to be submitted to be able to provide the formal additional status of that, from my understanding, unless the court has a different viewpoint.
No, Ms. Jordan, did you submit that form, the DC 539, to the court?
I did a request form on the website. I'm so sorry for the background noise. I did a request form on the website. And I sent in the SER application through that request form.
The court received that copy of your SER application, but there's a different form that needs to be filed.
Okay, I did not realize that.
Mr. Morton, I'm not trying to undo your consent judgment, but I'm just trying to be sure that we're being compliant.
What was the original? I'm just looking to see when the original hearing on this too was, Your Honor.
The 24th.
24th, so it's been more than 14 days from that original. I'm looking at the calendar so I understand my own timelines.
It is, and my understanding is that there was the copy of the SCR received on January 31st, which means that someone should have followed up for the submission of the 539. It does not appear that that was the conversation that was had at the original hearing on the 24th.
So there was no conversation about so the 539 was not submitted then, Your Honor?
It was not submitted. And what I'm saying to you, Mr. Morton, is that when Ms. Jordan appeared on January 24th, my notes don't indicate that she made the statement to the court that she had applied for rental assistance or would be applying for rental assistance, because my policy is to then say you need to file this 539.
Okay.
Saying all that to say, Ms. Jordan, that I'm just trying to work through the terms of work through the understanding of the newer landlord tenant court rules and the guidance that we've received. But that's just more to make sure that we're doing everything correctly.
Yeah, according to my notes.
I hear what you're saying, Mr. Morton.
Yes. I was going to say, Your Honor, according to my notes, I did have a note in here. Maybe this was in a breakout room, but I do have a note in here that we were aware of the assistance back at that original hearing date Was it, because then there was a discussion on some potential other opportunities about payment.
That being the case, the record now being completely muddled, Ms. Jordan, it was your understanding after having a conversation with Mr. Morton that a consent judgment will enter this morning. They indicated that you owe $5,035.10 in past due rent and that plaintiff was requesting costs of $190.24.
Yes.
And ma'am, that's the agreement you wish to enter, having received a copy of the advice of rights and viewed the advice of rights video.
Actually, when I came into the courtroom, the video did not play for me.
Did you receive a copy of the advice? Go ahead, Mr. Morton.
I was going to say, I believe, was it the advice of rights was provided at the first hearing? I think that's where some of the confusion might be as well, Your Honor, because I was going to say, so she should receive the advice of rights at the first hearing. Was it, as opposed to when she just came in for the second hearing as well, Your Honor?
I was referring to the first hearing. That's what I was saying. Ms. Jordan, when you appeared in court on January 24th, there was a video that it played that explained the rights you had available in this landlord tenant proceeding, correct?
I believe so.
And when you were served with a copy of the summons and complaint, there was a copy of that advice of rights form in that mail or posting?
Yes. Yes.
Just want to be clear that you've received those advice of rights, and having received those advice of rights and viewed the video, you wish to enter the consent judgment with the terms that Mr. Morton just placed on the record.
Yes.
Do you have any questions about your rights, ma'am, in this matter or today's proceedings?
No, not at this time.
Then, ma'am, the court will adopt the terms of the consent judgment that Mr. Morton placed on the record. His office will submit an electronic copy of that consent judgment. The court will sign it and the copy will be mailed to you at the address we have on record. Is there anything else in this matter, Mr. Morton?
No, Your Honor.
Is there anything else, Ms. Jordan?
Okay, I just want to be clear that we're not returning to court for another hearing?
No, ma'am.
Okay.
Anything else, Ms. Jordan?
No, I understand.
Then, ma'am, you're free to go. You have a good day. Good luck to you.
You too, Your Honor.
This is a recall of 2400176 T Harbor Club versus Norris.
Your Honor, Attorney Ian Morton, Palace Law, on behalf of the plaintiff.
Ms. Norris, you had a chance to speak to Mr. Morton?
Yes.
Mr. Morton, how are we proceeding?
Similar to the other case, Your Honor, the parties did speak and agreed to enter into proposed consent judgment agreement. I did advise her of the rights in regards to the fact that this would not be final for 3 business days. Second, the 10-day appeal period. And third, the ability to be able to sign her name to the proposed consent judgment agreement with the 2/19 date. Was it rents retained are $4,889.00. Court costs of $190.24 for a total of $5,079.24.
I'm sorry, 5,000.
$5,079.24. So 507924.
Thank you. Mr. Morton, we're closed on the 19th, so we'll be the 20th. Ms. Norris, you were able to hear Mr. Morton just now?
Yes.
And you wish to enter a consent judgment with the terms he just placed on the record?
Yes, I do have a question. So, okay, so with the consent judgment, what if I said no to the signing? What would that mean?
What do you mean? What if you said no to what part?
To my name being signed, what would that mean?
If you say no to entry of the agreement or just no to his office signing your name?
The signing my name, that's what I'm saying. Like, what would happen?
If you say no, then he'll have to send it to you. You'll sign it and you'll send it back to him, and then he'll file it with the court.
Oh, okay. Would I be able to do that?
Because if you,
or is that difficult?
Man, was it entirely up to you if you, I was going to say, Your Honor, it's entirely up to you, Ms. Norris, if you want to be able to do that. You just need to be able to, and I'll say this because other parties are listening, the idea would be we'd send it to you. The expectation is that it would be returned to us If we don't usually get it back within 24 hours, then we would instruct our procedure to go what's called a 7-day rule, which would mean then we would submit it underneath the 7-day rule, which would propose that the terms we just placed in the record were accurate. We're unable to get your signature, and we'd look for entry of it in that way, just present it to the court as what that way. So we get an email and send it to you, or we would, if we didn't get a response back within 24, we would then submit it underneath the 7-day rule. So again, which is more of a court procedure for entry of a judgment.
Okay, so if you email it to me, I can email it back?
Correct.
Oh, can we do that?
Sure.
Okay, thank you.
Are you okay with putting your email on the record here?
Oh yeah, that's fine. It's N, so 2 N's like Nancy, ORRIS.benefits, BENEFITS @gmail.com.
Okay.
Where
you
we
so
were, Ms. Norris, is, ma'am, when you appeared on January 24th, you would have reviewed a video that explained the rights you had available to you this morning?
I actually did not receive the video.
You didn't watch a video when you were here back on January 24th?
Oh yes, on the 24th. Yes. Sorry.
Okay. And then when you were served with a copy of the summons and complaint, there was a copy of that advice of rights in that mail or in that posting?
Correct.
And you understand the rights you have available in this matter?
Yes, ma'am. Or yes, Your Honor.
And you wish to waive those rights and have the consent judgment entered with the terms that Mr. Morton placed on the record?
Yes.
Do you have any questions about today's proceedings or the consent judgment that will be sent to you for signature?
No.
Then Mr. Moore's office will prepare that document, send it to you for signature. You'll get it filed. Once it's filed, I will sign it and a copy will be mailed to you at the address we have on record. Is there anything else in this case, Mr. Morton?
No, Your Honor.
Anything else, Ms. Norris?
After filing for the rental assistance, what am I supposed to submit to the court?
When did you file for rental assistance?
No, I'm saying after I do file for rental assistance.
If you do, then there's a form called a DC 539. It is on the court's website. Or if you want to speak to a member of the court staff about it this morning, we can get you moved into a breakout room to discuss it.
Oh, I'm okay. I just needed to know what it was called, but thank you.
DC 539. Other than that, ma'am, I'll sign the consent judgment once you both sign it and submit it.
Okay.
Have a good day, ma'am. You're free to go.
You too. Thank you.
Thank you. 23034646 LT Holiday West versus Long. I have your appearances.
Thank you,
How are we proceeding this morning?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $5,474.82. Cost of $190.24 for a total balance of $5,665.06 to be paid on or before February 20, 2024. I did advise her of her rights under MCR 4.20J, and she's also given me consent to sign a name to the judgment.
Thank you. Ms. Long, were you able to hear the attorney just now?
Yes, ma'am.
And having had a chance to review the video explaining the rights you have available in this landlord tenant matter when you appear back on January 24th and receiving a copy in the mail, this is how you wish to resolve this case.
Yes, ma'am.
Ms. Long, do you have any questions about the rights available to you or this morning's proceedings?
No, ma'am.
Then, ma'am, the court will adopt the terms of the consent judgment just placed on the record. Ms. Kuzi's office will prepare it, file it with the court electronically. I'll sign it and a copy will be mailed to you at the address we have on record. If you have no questions, ma'am, you're free to go. You have a good day.
You as well. Thank you.
Thank you. Oh. What happened to? What happened with Ms. Robinson, Danita Robinson?
Your Honor, I believe we have not spoken with the tenant. I will go ahead and go in that breakout room and come back in the main session for another matter that is ready.
What's the other matter, ma'am?
The case number is 2400169 LT. It's in regard to the Waverly on the Lake versus Tamika Kennedy.
2400169 LT Harbor Club versus Kennedy.
State your present behalf of the plaintiff.
Ms. Kennedy, you had an opportunity to speak to the attorney for your landlord.
Yes.
How
are we proceeding this morning, Ms. Kuzi?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $3,811, cost of $190.24 for a total balance of $4,001.24 to be paid on or before February 22nd, 2024. I did advise her of her rights under MCR 4.20J, and she's also given me consent to sign a name to the judgment.
Thank you. Ms. Kennedy, you were able to hear Ms. Kuzi just now?
Yes.
And ma'am, after having an opportunity to review the video, go ahead.
So I wanted to ask about rental assistance.
What's your question, ma'am?
So would it be possible for me to apply for rental assistance? Because I believe that's what the lawyer told me to ask you.
What lawyer?
Your Honor, I did advise her of her, I believe she did not show up at the first hearing. Another occupant did show up, and she did ask in regard to the rental assistance. I did advise her that she was given the resources when she was served with the pleadings to go ahead and go through those documents, and if she needed additional information to contact the court. And I also did advise her about the seeking rental assistance with DHS. However, as of today, she has not applied for rental assistance.
Ms. Kennedy?
Yes, ma'am.
When this case was scheduled originally on January 24th, you did not appear. The occupant, your daughter, appeared. There was a video that played that explained the rights that were available to you. When you were served with a copy of the summons and complaint in this matter, it included forms that were the advice of rights and resources that were available to you. To short answer to your question, you can always apply for rental assistance. You don't have to wait to be sued by your landlord. You don't have to wait for judgment. And there's nothing that stops you from applying even at the conclusion of today's hearing.
Okay, then. Thank you. That's all I wanted to ask.
Okay. And that conversation now having been had, and you heard the terms of the consent judgment that were placed on the record by the attorney, is that how you wish to proceed this morning?
Yes, ma'am.
Ma'am, do you have any questions about the rights available to you or to this morning's proceedings?
No.
Okay, then ma'am, the Palace Law Firm will prepare a consent judgment with those terms submitted to the court electronically. I will sign it. A copy will be mailed to you at the address we have on record. You have a good day.
Thank you, you too.
Thank you. Now, I saw someone else.
Your Honor, depending on the procedure that you're moving forward, Martina Stewart, which is Hot Perks, that's one that is a second hearing. If you'd like to speak to them briefly, and then we could maybe go into a breakout room and speak to them.
What we'll do is, I had an 11 o'clock trial schedule. I'm going to call that. Everyone else should get matched up with the attorneys and the tenants should get matched up and moved into breakout rooms. If you're not sure, Marianne or Carly or whomever's on for the civil department will get you matched up. If there's anyone looking for the assistance of Lakeshore Legal Aid this morning, the clerks will ask you that as well. And after conclusion of this morning's trial, we'll pull everybody back in and recall those cases and get people seen and heard. This is 2302873 LT. This is Olivia Smith versus Orlino Boston. State your names for me, please.
Orlino Boston.
Olivia Smith.
And good morning, Your Honor. George of Lakeshore Legal Aid on behalf of Ms. Boston. I was just retained yesterday and I have an appearance that is going to be sent in shortly now that I have Ms. Smith's email address.
Mr. George, were you ready to proceed this afternoon or were you looking for an adjournment?
Your Honor, I'm happy to report that we have agreed on the terms of a conditional dismissal. This was filed as a
Okay.
termination of tenancy case, so there is no money involved. Ms. Boston does agree to vacate the premises on or before March 1st. If she fails to do so, Ms. Smith would be able to come back and reopen the case and proceed from there. I will be preparing that conditional dismissal this afternoon, and I will email it to Ms. Smith for her signature. She can email it back to me, and I will file it with the court.
Ms. Smith, were you able to hear Mr. George just now?
Yes,
And was that the agreement that you reached with him?
that's correct.
Do you have any questions at all about the conditional dismissal that will call for Ms. Boston to vacate the property by March 1st, 2024?
Just if I have to bring it back to court, do I have to refile?
No, ma'am, there's the conditional dismissal has there's an affidavit that you can submit to have the case reinstated and rescheduled, correct, Mr. George?
That's correct, Your Honor. So, Ms. Smith, you would not have to file a new case. You would come back to court and reopen this case. But of course, we're hoping that that won't be necessary.
Did that answer your question, Ms. Smith?
Yes.
Do you have any other questions, ma'am?
No.
Then that concludes this matter. We'll await receipt of the conditional dismissal. I'll sign it and it will be mailed out to you at the address we have on record. Thank you for working to come up with a settlement of this matter. You all have a wonderful day.
Thank you.
Thank you.
Thank you.
And Your Honor, I need to sign off for a meeting here, so I'm going to leave you in the capable hands of Ms. Pruknick and Mr. Court.
Thank you, Mr. George. Have a good day.
You do the same.
Miss Robinson, this is a recall of 230365 LT Holiday West versus Robinson. I note your appearances. Ms. Kuzi, how are we proceeding?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $3,047.48. Cost of $190.24 for a total balance of $3,237.72 to be paid on or before February 20, 2024. I did advise her of her rights under MCR 4.201J, and she's also giving me consent to sign her name to the judgment.
Thank you. Ms. Robinson, were you able to hear Ms. Cozy just now?
Yes.
And ma'am, after having the opportunity to speak with her, that's the agreement you wish to enter.
Yes.
When you appeared on January 24th, there was a video that played that explained the rights available to you. Do you remember that video?
Yes.
And when you were served with the summons and complaint, you received a copy of those advice of rights. Do you remember receiving that document?
Yes.
Do you have any questions about the rights available to you, ma'am?
No.
And Ms. Robinson, you submitted to the court a copy of an application for assistance. What was the status of that application?
I got denied.
Thank you. Ma'am, the court will enter the terms of the consent judgment that the attorney just placed on the record. She'll prepare it, submit it to the court electronically. I will sign it, and a copy will be mailed to you at the address we have on record. Is there anything else on behalf of Holiday West?
No, Your Honor.
Anything else, Ms. Robinson?
No, that's it. Thank you.
Then, ma'am, you have a wonderful day. You're free to go.
Thank you.
Thank you. Ma'am, Ms. Coolsey, did you speak to Mr. Damon Mason?
No, Your Honor. I will go in a breakout room right now and speak to him.
Thank you.
Good morning, Your Honor. This is Raymond Court from Lakeshore Legal Aid. I just wanted to let the court know that I'll be filling in for Danette McElmore on Pinewood Circle versus Garrett at 11:30.
Thank you, Mr. Court.
You're welcome.
Have you spoken to Mr. Katz?
I have not.
I have not seen him this morning, but as soon as he gets here, we'll get you connected with him.
I appreciate that. Thank you, Your Honor.
You're welcome.
Is the trial proceeding, Your Honor?
No, it's not.
Okay, then I'll bring two more people in to be able to put on the record. I wanted to check before I brought them in.
You don't want to just come in here screaming and yelling? Thank you. I appreciate that.
I leave that to my 2-year-old.
Two. Oh my gosh. Oh my gosh, that was fast. Holy smokes. You probably don't see it that way, but that's how it feels.
It goes quickly, but then it's also it moves slowly. It's an interesting thing on time.
This is 2400184 LT. This is Harbor Club versus Hot Perks and Wiltgen. Ma'am, would you state your name for the record, please?
Ms. Stewart.
Ms. Stewart. Is she, Ms. Stewart, are you downstairs in our lobby? Hold on.
Can you hear me?
Yes, ma'am.
Yes.
State your name.
Oh, Martina Stewart.
Ms. Stewart, you had a chance to speak to Mr. Morton this morning?
Yes.
Mr. Morton, how are we proceeding?
Your Honor, just to give some background, so the lease leases directly with Hot Perks Michigan LLC, which is a company that, you know, obtains housing for people, and then they have an opportunity, and then it's primarily through that company, and then that person is listed as an occupant and is residing in there. So Ms. Stewart is residing there, through a lease with Hot Perks Michigan LLC. So in respect to that, she is not a signed leaseholder, which she understands that. And I told her that she has the option if she wants to formally be added or not, but she cannot be forced to be added. So she has chosen not to sign the formal judgment today because, again, she is not a signed leaseholder in this case. Based on that, Your Honor, we're going to seek a default for rents retained of $6,990.65, court costs of $248.83, for a total of $7,239.48. With a date of 2/20/2024 as the payment or move out date. Ms. Stewart has additionally advised me that she is actually looking and is in the process of moving right now. And this is a possession only action. I did go over the rights very briefly with her, but again, she's not signing So I told her that, this would be different because she's not signing as a leaseholder because she is only an occupant that was approved underneath the hot perks, was it listing?
Thank you. Ms. Stewart, were you able to hear Mr. Morton just now?
Yes.
Is everything he said correct, ma'am?
Yes.
And you understand why a default judgment will be entered at this time?
Yes.
Do you have any questions about this morning's proceedings?
No.
Then, ma'am, the court will enter default judgments as to the named defendants in this matter. I do understand that you are the occupant there and you're electing not to sign the lease. We had the conversation, at least in part, when you were here on January 24th. But the court will sign the default judgment. If you are in the process of vacating, please be sure that you follow the procedures to properly notify Harbor Club that you are vacating in terms of cleaning, turning in keys, et cetera, okay?
Okay.
Anything else, Mr. Morton?
No, Your Honor.
Thank you. Then, Ms. Stewart, that concludes this matter. You're free to go. You have a good day.
You too. Thank you.
Thank you. Mr. Katz, Mr. Court is here for Ms. McLemore on the Pine Woods versus Garrett matter. Would you like the opportunity to speak to him? I'll take that as a yes. Mr. Schlesinger, good morning, sir.
Good morning. Good morning, Your Honor. How are you today?
I am super. How are you?
Doing well. Thanks for asking.
We've managed to get out of the weeds and get almost back on track in terms of our schedule, I think.
Very nice.
Hey, I'll take that.
Nose to the grindstone to get you somewhere.
Miss Matthews.
Yes.
I'm just looking for your case.
That is
number.
Rawsonville 24-00089 LT.
This is Rawsonville Woods versus Felicia Matthews. Ma'am, you've had the opportunity to speak to a representative from the Palace Law Firm?
No.
Ms. Matthews, you had a chance to speak to myself, Attorney Ian Morton, correct?
Oh, okay. Yes.
Okay.
Mr. Morton, how are we proceeding?
Your Honor, the parties did speak. We agreed to enter into proposed consent judgment agreement. Rents retained are $3,782.27. Core costs of $190.24. We're told $3,972.51. I did advise her of her rights, specifically the fact that the agreement would not be final for 3 business days, as well as the fact that she does have the 10-day appeal period. And finally, she did give me permission to sign her name to the proposed consent judgment. She intends to be able to pay this off. I think she even said sooner than the 20th, but I told her that she would minimally be provided to the 20th to be able to make that payment as she's exploring other opportunities outside governmental assistance programs to be able to make the payment on the balance.
Thank you. Ms. Matthews, you were able to hear Mr. Morton just now?
Yes, I was.
And you appeared back on January 24th. You had the opportunity to review the video that explained the rights you have available in this landlord tenant matter.
Yes.
And ma'am, you also received a copy of that advice of rights in writing when you were served with the summons and complaint.
Yes.
And after having a chance to review that video and review that printed advice of rights, you wish to enter the consent judgment with the terms that Mr. Morton just placed on the record.
Yes.
And before the court accepts those terms, do you have any questions about the rights available to you or this morning's proceedings?
I just have one question. I did say that I should be able to get full payment in before the 20th, but if I get it in by the 20th, will I still have the next late fee added onto that or no?
Man, what I can tell you is that the judgment amount will not change. So if you pay that judgment amount by the 20th, then this case is done. If you run into any issues with that, my contact information, the phone number for my office is listed on the judgment, and I can correct any confusion that may take place. But again, that judgment amount is what's going to stand and what you have the opportunity to be able to pay by the 20th to be able to avoid an order of eviction potentially moving forward.
Okay.
Any other questions, Ms. Matthews?
Nope, that is it.
Thank you, ma'am. That concludes this matter. You're free to go. You have a good day.
You too. Thank you. Bye.
This is 2400173 LT. This is Harbor Club versus Mason and Mason.
Hello, Your Honor, Cindy Jacuzzi on behalf of the plaintiff.
I'm sorry, Ms. Kuzi. Mr. Mason did come back and now he's.
I'm here.
Thank you. Turn your video on and state your name for the record, please.
Damon Mason II.
Mr. Mason, where is the other Mason?
I'm right here.
Thank you. You've had the opportunity to speak to the attorney for Harbor Club.
Yes, I have.
How are we proceeding this morning?
Yes, Your Honor, we did agree to a consent judgment. Rent to retain is $998.52. Cost of $248.83 for a total balance of $1,247.35 to be paid on or before February 20, 2024. I advise them of their rights, and they've also given me consent to sign their name to the judgment.
Thank you. Ms. Mason, Mr. Mason, when you appeared here on January 24th, you had the opportunity to review the video that explained the rights you have available to you in this landlord tenant matter.
Yes.
You also received a copy of those advice of rights in writing when you were served with the summons and complaint.
Yes.
You heard the terms of the consent judgment placed on the record this morning by the attorney.
Yes.
Do you have any questions about the consent judgment or the rights available to you in these proceedings?
No.
Ma'am?
No.
Then Ms. Kuzi's office will prepare a consent judgment with the terms just placed on the record. We'll file it electronically with the court. I will sign it and the copy will be mailed to you at the address we have on record. You're free to go. You have a good day.
Thank you. You too. I appreciate it.
Thank you. Mr. Katz and Mr. Court, were we ready on Pinewood versus Garrett?
We are, Your Honor.
This is 2302887 LT Pinewood Circle versus Shatima Garrett. Your appearances, please.
Good morning, Your Honor. Sidney Katz on behalf of plaintiffs.
Good morning, Your Honor. Raymond Court, appearing on behalf of defendant Shatima Garrett, who is present on the Zoom.
Thank you. Today was the day and time for the last adjournment of this matter. The parties have had the opportunity to speak. Mr. Katz, how are we proceeding?
Your Honor, this is going to be a consent judgment. There is currently a balance due, and Mr. Court, I don't think I gave you the numbers to include on that judgment. $5,901 of rent, $170 of cost for a total of $6,071. Ms. Garrett has until February 20th to either pay that amount or vacate. She does intend on vacating. I did indicate to Mr. Court, who is going to prepare the consent, that if she does comply with the judgment and a writ is not issued, if presented with a stipulation to set aside, we would agree to it.
That's correct, Your Honor. Mr. Katz, can you give me those numbers one more time, please?
Yep. 5,901 of rent, 170 of costs for a total of $6,071.
All right, that's what I had. I just wanted to double check. I appreciate that.
Great.
Thank you.
That is
I'll make
accurate,
the
Your
notes
Honor.
in the file. I'm sorry, Mr. Court, you were
I
saying?
was just going to say that was an accurate rendition of our agreement.
Thank you. I'll make notes on the ROA. We'll be looking for that signed consent judgment here the next day or two. Anything else in this case, Mr. Katz?
Not as it relates to this case, no, Your Honor.
Anything else, Mr. Court?
No, Your Honor.
Any questions, Ms. Garrett?
No, ma'am, I'm sorry, I was muted.
No worries. That concludes this matter, ma'am. You're free to go. You have a good day. Good luck to you.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome.
Your Honor, I apologize. I had court with you last week. I did not know that I had a docket with you until afterwards because there's an e-filing issue. So
Have you resolved your e-filing issue?
This is a across the board e-filing issue. We don't get notification. They don't send us any of the notification of the cases, and it showed up on our system as temporary until 2 days before the court date. So we're looking into it. It's a big issue. So just wanted to let
Any
you know.
suggestions?
And he said, yeah, let's go back to the old ways pre-COVID.
You want to stand in the hallway with 30 cases? That's what you want to go back to?
You know what? It was a lot more efficient sometimes, Your Honor, and I only had to come to court once. So, all right. Well, we'll hopefully figure it out, Your Honor. I will see you. Thank you. Have a good day.
Thank you. You too. Mr. Schlesinger, give it maybe 6 more minutes unless you're dismissing the Hudson matter.
No, not dismissing. We're proceeding. So yeah, I'll wait as long as Your Honor wants me to.
It's 15 minutes after the scheduled start
Okay.
time, like I said. Oh, he's in with Lakeshore.
Okay.
Mr. Hudson's in with
again?
Lakeshore Legal Aid.
All right. He met
Thank
with.
you.
All right. I was in person the other day. I stopped down to see you, but it was too late. The courtroom was locked up.
What time was it?
I don't. I had a couple of hearings with Judge Oakley at like I had a 1:30, a 2, and a 2:30. I was in person, so I probably was done by about 3, and your courtroom was locked up, and I didn't feel like going to staff to say, "Hey, can I go back and see Judge Martin?"
Oh, in the future, just call because I'm here until 4. My
Okay,
courtroom was locked because I might not have had a in-person docket.
I'm sure. But yeah, I
Okay.
hadn't seen you in a number of years. I hadn't seen you since you got See, did you were appointed, right?
No, sir, I was elected.
Okay, I'm trying to remember back. So I know you were running, but I thought you got appointed first and then ran when it was open. So you straight up ran. Good for you. It's been a while now,
I
right?
straight up ran in the throes of COVID with nobody wanting to answer the door or speak in person. But no, the next time you're here, please let the staff know. If you're downstairs, I'll come down and I'll be back out as soon as Mr. Hudson's ready with Lakeshore.
Excellent. Thanks, Judge.
Thank you. Take your hat off, sir, please. This is 2302861 LT. This is Wellesley Townhomes versus Ronald Hudson.
Yes.
Thank you. Mr. Hudson, I realize you were in speaking with Lakeshore Legal Aid, but this case was scheduled at 11:30. It's 11:51 by my clock. Mr. Swessinger, the attorney for Wellesley, is here, and this court needs to recess to go to lunch. On behalf of Lakeshore, what's the status of your intake with Mr. Hudson?
He has qualified for assistance, Your Honor. I was in the process of getting a retainer agreement from him. If I could speak with Mr. Ravitz regarding an agreement with him.
It's not Mr. Ravitz, it's Mr. Swessinger.
Oh, I'm sorry, Mr. Swessinger.
That's okay. We can get you into a breakout room with him. I just didn't want the attorneys sitting. So we'll get you moved, Mr. Swessinger, in with Lakeshore and Mr. Hudson.
Thank you.
Thank you. Ms. Kuzi, same thing. I'm about to pull the Becker and Ms. Johnson out so we could, oops, shoot. What happened? This is 2400164 LT. This is Harbor Club versus Johnson. Ms. Johnson, I understand that you were in speaking with Ms. Becker from Lakeshore, but this case was scheduled at 11:30. It's now 11:53 by this court's clock. Ms. Becker, what's the status of your office's retention in this matter?
Hi, Your Honor. I did the initial intake for our process, but she hasn't had a chance to speak to an attorney yet. We were still waiting for someone to become available.
Okay, Ms. Johnson, have you made an application for rental assistance?
Yes, I did.
With what agency, ma'am?
The Department of Human Services.
I'm sorry?
The Department of Human Services.
When did you make that application?
Last couple weeks ago, right after I had the first court thing.
Ms. Kuzi, what we'll do is we'll adjourn this matter over to the 22nd at 1:15. Ms. Johnson, we'll put you back in with Lakeshore. If they have an attorney available, we'll leave the Zoom open so that you can meet with that person. Additionally, ma'am, you will need to file a form that's called a DC 539. The Lakeshore representative will be able to walk you through what that means. It's available on this court's website. Excuse me, but I wanted to be able to release the attorney's office. So we're adjourning this matter over. Anything else, Ms. Cozy, in this matter?
No, Your Honor.
Thank you. Ms. Becker and Ms. Johnson will get you back into your breakout room.
Okay, thank you.
Thank you. Mr. Court and Ms. Ford, this is 2400159 LT Harbor Club versus Ford.
Hi, I'm here.
Good morning
I
again,
don't
Your
see
Honor.
anyone, I'm sorry. Thank
Hi.
you. Mr. Court, my apologies for interrupting your conversation, but this case was scheduled at 11:30. It's now 11:55 by the court's clock. The attorney is here for Palace Law Firm. What's the status of your conversation with Ms. Ford?
I was just advising Ms. Ford on her need to file the status update DC 539 form. She told me that she had filed it about January, the initial form about January 24th, and she hasn't received a determination yet.
Will your office be retained in this matter, sir?
I'm not sure. We were
Okay.
pretty at the start of the conversation, but if the court is going to be adjourning it to allow Ms. Ford to file her status update, I'd be more than happy to continue my conversation with her.
We will move her back into the breakout room. You may continue that conversation with her. The court did receive the 539. Thank you for the update. We'll adjourn this matter over to February the 22nd at 1:15 p.m. Anything else on behalf of the plaintiff?
No, Your Honor.
Anything else on behalf of Ms. Ford?
No, Your Honor. Ms. Ford, do you have anything you'd like to add?
No, ma'am.
Mr. Court, we'll put you back in that breakout session. If you want to continue speaking with her, please do so. I just want to get the this courtroom cleared out.
Absolutely understood, Your Honor.
Thank you. Did we see, is your last case here too? Palmer Centers?
Yes, Your Honor, that's my last case, but I have not seen the defendants show up.
I'm double checking, triple checking. This is 2400093 LT. This is Rawsonville Woods versus Samantha Palmer and Megan Centers. This case was scheduled at 11:30. It's now 11:57 by this court's clock. There are no unidentified persons in this court's main session. There are no unidentified persons in the court's breakout sessions. The defendants having failed to appear, ma'am, how would you like to proceed?
We are requesting a default possession judgment. Rent to retain is $2,563. Cost of $248.83 for a total balance of $2,749.46 with a writ to issue after 10 days.
Thank you, ma'am. Please submit the default judgment with those terms on it. Is there anything else from you this afternoon?
No, Your Honor. Thank you.
Thank you. Carly, how long will you be around?
Until you tell me to leave you alone.
There's only one case left that might potentially come back on the record, and I don't know, Mr. Schlesinger and Mr. He's in with Mr. Hudson. I don't want to interrupt them, but we need to take a recess so that we can be ready for the 1 o'clock. Ugh. Mr. Porter, are you back with good news?
Miss Ford is going to be filing that status update on her own and then sending me her court paperwork to see if we can represent her.
Oh, no, I meant good news about Mr. Hudson.
Oh, I have an update on that. My colleague Patricia Prutnick said she is almost done negotiating with the plaintiff counsel on that.
Okay, the issue for this court, and I already advised the other members from your office, we start up again at 1 o'clock and we're trying to take a recess if possible. So
I can see if I can nudge it along, Your Honor.
I don't want to force anybody, but I just kind of want to be fair to
court staff.
So Carly, if you want to go, you can go. I think we're going to probably start up a little late after lunch.
Sounds good.
Thank you, ma'am. Mr. Schlesinger, Mr. Hudson's still in with Lakeshore.
Yeah, I assume they'll be coming here in a second. We worked out an agreement. Sorry for the delay there.
No worries.
I hope you found something to do to kill your time.
Note my files and on base.
Are you this afternoon? I got to come back this afternoon. Are you? Will I
I'm
see
back
you
this afternoon. That's why I'm trying to recess right now.
All right.
This is a recall of 2302861 Wellesley Townhomes versus Hudson.
And Mark Swester again for plaintiff, Your Honor.
Patricia Prutnick, Your Honor, I spoke with Mr. Hudson today.
Thank you. And Mr. Hudson, as he appears to still be in the breakout rooms.
Nope.
Here he is. The parties have had the opportunity to speak. How are we proceeding this afternoon?
Your Honor, the parties have worked out a consent judgment. If I may, I'll put the terms on the record.
Please do.
Thank you, Your Honor. This is going to be, as I stated, it's be a consent judgment, possession only. Presently, we're showing $1,791.36 rent to retain, court cost of $185.75. Total to retain possession, $1,977.11. The writ, if it's not paid or Mr. Hudson hasn't vacated, writ to issue after February 29th, 2024. And we have also indicated in the 10 section, there may be a reduction in Mr. Hudson's rent that may be applicable this month. We're not entirely sure. We couldn't get a hold of my client, but if it's been reduced, then Mr. Hudson will be entitled to a corresponding reduction in the amounts in 4D to reflect for the possible rent reduction for the month of February.
Is that a correct statement of the agreement reached by and between the parties?
Yes, Your Honor.
Then Mr. Schlesinger, the court will note the file and will await receipt of a document with those terms on it. Anything else on behalf of the plaintiff?
Nothing further, Your Honor.
Anything else on behalf of the defendant?
Nothing further, Your Honor.
Thank you. Mr. Hudson, thank you for your patience this morning, sir. You have a good day. You're free to go.
All right. Thank you. Have a good one.
Good luck, Mr. Hudson.
Thank you.
Thank you. Thank you, guys.
Thank you.
Take care.
And this
Thanks,
court
Judge.
will stand in recess until 1:15. Thank you.